All right, Keith, good morning. It is day 56 of the Lively versus Baldoni case. There has been another filing in the Southern District of New York Federal Court, and you're
This
going
is
to
a
go.
good one.
It's a good one. You're going to go over that in just a few minutes, and it has to do with the SNL skit potentially coming back to bite Ryan Reynolds and Blake Lively in the rear end. And you're going to go over that. But before we go over that, Keith, we did have several people reach out, and they want to know kind of how the sausage is made in these cases. And you and I, we've been litigating for 20 years each, and we have some. We're bumbling fools for the most part, but we're
But we get
okay
by.
at what we do. And so, let's say that you and I were hired on this case today, and it wasn't a case that everybody already knew about. And we need to learn about this case. And so, how do we as lawyers come into a case? How do we want to learn about the case? How do we advocate on behalf of our clients? How do we form strategies? These are all things that we need to do as lawyers. But you got to start from square one. It's like walking into a dirty room and you don't know where to start. You got to start somewhere. And where you and I have started is we have decided that we need to learn the cast of characters in a case. And so what you and I will do is we literally will pull anything we can find from any documents our clients give us, any text messages or emails. In this case, since the case has already started and we're brand new to it, well, we would look and we'd see that Judge Louis Lyman is the jurist in this matter. He's going to be important because he's going to be making many decisions in this case. And then, of course, we want to know the cast of characters for the attorneys. And here, the lead attorney for Baldoni is Brian Friedman. And I think I spelled his name wrong there. My apologies. I think it's Freedman. And then you've got attorney Ezra Hudson, who's heading up the Lively team for the litigation. And then I've got some other names there. Jamie Heath, Justin Baldoni.
You spelled Sarowitz correctly.
Did I get
that's good.
Well, good. I got Sarowitz right. We got Wayfair, and then we've got a bunch of other things. So that's one thing that we're going to do is, and we're going to do a deep dive into each one of these individuals. And many times, what we'll do is we'll simply just start with looking up some websites to see what it is about these individuals. And I like to see pictures. Not everybody does, but I like to start with pictures. So here, for example, we're looking up Judge Louis J. Lyman. And Keith, we want to know everything about this judge. We want to know how many kids he has. And here we see he has 2 kids. We want to know what political party he came from. We can see here at Wikipedia, he was a Democrat. We can see that he's 64 years of age. So we're already getting intel. We're getting data, and intel is important. And so we're finding out about the judge. And we also want to find anything this judge has written on in his time as a judge on SH cases. We want to know what statutes he's pointed to,
what decisions he's made,
what verdicts have come down, what case law he has written in his decisions. And we also want to find anything that he wrote while he was a lawyer. We want to find everything because if you have data on a judge, you want to know how they think, how they look at these cases. And many times they're paid advocates when they're a lawyer, but still their personality, their thinking, how they analyze these cases, it comes out. And so that will help us as a judge. The other thing we want to do is we want to look up Brian Friedman. And I was interested. I went right to his website, and he must be a humble guy because most lawyers have a big picture of themselves and they're smiling with their expensive veneers and they're
on the steps of the courthouse or something like that.
Yes. Pointing to the sky and Brian Friedman. But the nice thing about it is you come here and you look at the awards and recognition. People will write important things in their profiles as a lawyer, whether he wrote these or somebody else did. You're going to get some insights into Brian Friedman.
Yeah, you need to know who your adversary is if you're on the opposite side of Brian Friedman. Now, he's a pretty famous lawyer, so maybe you already know that. But if you don't, you want to look it up.
Look it up. And then here we have Ezra Hudson. And here I found an article in the Daily Journal. And boy, she's going to give the reporter her best stuff, right? She's not just going to say, I'm a boring individual. So you'd want to read this whole article. And you can see here, just for example, that she has a reputation as a preferred employment advisor. And that here she has a quote. She goes, I began practicing labor and employment law as a summer associate, and I was hooked from the start. So, from an experience standpoint, she's been doing this for a long time, just from that one sentence.
Yeah.
And that she likes this stuff.
And that she has a passion for it. So she probably is very well versed in it.
Right. So that would be something that you'd want to do, and just a little background on the case. And ultimately, Keith, what we want as lawyers is we want to know the facts better than any other lawyer in the case. We want to know the witnesses. We want to know what the witnesses are going to testify to. If we don't know what a witness is going to testify to, what are we going to do?
You have to depose them.
Got to take their deposition. And the reason we take depositions is we can ask them 8 or 9 different ways the same question at deposition, get the answer we're looking for, a clean transcript. And then at trial, if that witness strays away from that testimony, what do we do with that deposition transcript?
You can impeach them. You also can use the transcript to outline your trial questioning and help lead them. And there's going to be a lot of depositions in this case because there's a lot of unnamed sources and other people that we've heard about and we've been talking about. All of those people ultimately are going to be deposed, and it's going to be very interesting to see what they have to say.
So as we learn about this case ourselves as lawyers coming into it, the facts, the witnesses, the documents, by the way, the documents, that's where you really make your money as a lawyer, because you've got to know those documents better than anybody else. You got to know which are the important documents, which ones help you, which ones hurt you, which ones are neutral. You got to categorize them. Being organized as a trial lawyer is super important. And if you're organized and you have the truth on your side, you're going to win 9 times out of 10 just on that alone. You don't even have to be that talented of a presenter as a lawyer if you have the truth and you have organization on your side.
Yeah.
Documents, when we're going through them, you're going to come across videos, and you're going to come across the Forbes video.
Especially in this case.
You're going to come across the Forbes video where Lively says right there that she comes into these cases saying she's just going to be an actress, but then she tries to take over. And that's allegedly what happened here in this case with this movie. And so you're finding these pieces of evidence. That would be a very favorable piece of evidence. In fact, you'd probably want to play that in opening to the jury and in closing and in cross-exam and anywhere else you could. You would show the experts. Lively's experts are going to show up and say there was SH happening here. And then you would say, well, what do you do with this? Did you consider this video? Did you even consider that this might have been where she was just upset that she didn't get her way, and now she's using SH as a way to come after Baldoni and hurt him and harm him because she couldn't get her way. So those are things that you're going to use. So that's why it's so important. Well, that leads us to today, Keith. There's this subpoena issue, which I want you to walk us through, tell us what's going on there. What is the strategy of both sides? What are Lively's lawyers trying to do? What are Baldoni's lawyers trying to do? And let's start with some stuff we downloaded from the courthouse today.
Yeah, and the latest filing came in this morning, and it's a doozy. But let's talk about how we got here. And if you remember, this all started because the Lively side issued subpoenas where they wanted all calls and text messages from Baldoni and the Wayfarer parties. And Baldoni said, wait a minute, you don't just get to come in and ask for 2.5 years of everything I've ever communicated with everybody in the world. And then the judge said, hey, you guys talk to each other, figure it out, which is common. And in almost every discovery dispute, the judge is going to say there's a meet and confer requirement. You attorneys have to sit down and try to figure it out. Well, apparently, according to the letters that have been filed both yesterday and today, they figured some stuff out, but they haven't come to a complete agreement. So there's still a little bit of a disparity in terms of where they're at. And the story really starts in terms of understanding what the arguments are back and forth and what they figured out. What the document was filed yesterday, this is document number 93. And this is a document from the Baldoni parties to the judge talking about what their position is and what they've agreed to and what they haven't agreed to, more importantly. And if you look at the second paragraph of this document 93, you'll see that the Lively parties did agree to withdraw their requests in their subpoenas for all documents. So they're not asking for all documents anymore, data logs, and cell site location information, which I guess would dictate or tell you where somebody was located when that communication went out.
So let me ask you, when the subpoena first went out by Blake Lively's team to Justin Baldoni and said, hey, give us 2.5 years of all documents without limitation pertaining to your phone, your cellular carrier, that would include text messages, call logs, everything. And of course, now it sounds like Lively's attorneys are doing what?
They're agreeing to limit that. So now they're coming back and saying, okay, look, we'll withdraw all documents, data logs, cell site location information. So that's what they are agreeing to withdraw. Here's what they're not agreeing to withdraw. And that takes us to the next paragraph. And so there are some things that they are not agreeing to take back yet. And that is they've refused to withdraw the request for call and text logs. So the problem that Baldoni's attorneys are pointing out here is that, well, look, if we give you all call and text logs for the last 2.5 years, that's going to include every call or doctor that somebody made to, or every call or text somebody made to a doctor, a medical practitioner, a lawyer, a relative, a friend, employee communications. I mean, you're still getting too much information. It's going too far. And so that's where the dispute still is between the parties. So there's been some narrowing by Lively's side, which naturally they have to, because if they don't, the judge will. But they haven't gone far enough, according to Baldoni's argument.
Why do you think that Lively wants 2.5 years of this cellular data? What is Lively's team trying to get out of this?
They're trying to find any calls or text messages that's going to support their argument that there was a secret smear campaign orchestrated by Baldoni. And so they want to find communications, apparently, where either Baldoni or somebody on the Wayfarer side is sending a text to somebody saying, okay, let's do that secret smear campaign and let's start it now and let's, do this and that. And so really they don't know what's out there. And so they're trying to find anything they can.
And so Baldoni, let's say that he is innocent of this, and I'm just saying that as an assumption. Why wouldn't he just turn over 2.5 years of text data? I mean, why would Brian Friedman, why is Baldoni saying, hey, you don't have a right to this information?
Well, because it's just too broad. And there's actually two standards that we need to think about when it comes to these things. So the first standard is just the standard you use for all discovery. And the question is it reasonably calculated to lead to admissible evidence? So in any lawsuit, you don't have the right to just go out and find anything and everything. It is limited in that sense. It's a very broad limitation, but it is limited. So think about that. You have the right to admissible evidence, and you have a right to discover any roads that lead to admissible evidence, and that's it. But then there's a second, more stringent standard on top of that, and that comes in with the right to privacy. So for things like medical records, or if I send a text to my doctor, or if I have bank and brokerage account information, that all falls under the right to privacy. But the right to privacy is not absolute. It can still be discovered. But that's when you get into the standard that it has to be narrowly tailored. So you're only getting what you need for the lawsuit, and it has to have a direct connection to the issues in the lawsuit. That's a much more narrow standard than what we use for discovery generally.
So when the public at large, the PR campaign that's going on between both camps here, if they're looking at this and somebody says, well, Baldoni, if he hasn't done anything wrong, why doesn't he just turn over all 2.5 years of text messages? Is that because Baldoni is worried that there's something incriminating out there? Or is it because he has a right to privacy and you don't just get a right to invade somebody's life completely when you're in a lawsuit?
Yeah, and that's the second. And I would feel the same way. We do the same thing for our clients in our litigated cases, which is, no, we're not going to just give you every text message this client sent to a doctor when it's not relevant to the lawsuit. You just don't get that. That's private information, and it's going to stay private. And you have a right to stand up and assert your right to privacy. It's not that those doctors, like if I sent text to my doctors, it wouldn't show that I was liable or guilty of some, legal act, but it might be embarrassing. It might be my private information that shouldn't be out in the public domain. So he has a right to stand up and protect his right to privacy, and he's doing that. Now, not every communication though, or not every text is going to fall under the right to privacy. If you're doing text messages between yourself and a PR person, that does not come under the umbrella of right to privacy. Right to privacy is private information like medical records, bank accounts, brokerage accounts, real estate transactions, that sort of thing. But you still have to show that any communications are relevant to the lawsuit. It has to be relevant to what you're trying to prove in the lawsuit. So let's talk about what Baldoni's attorneys suggest. So if we go down to the next paragraph in this document 93, we can actually show here it is what the Baldoni side is recommending and what they suggest should happen on these subpoenas, which actually sounds quite reasonable to me, which is it's about halfway down there. It says, we suggest that the Lively parties limit the subpoenas to seek calls and text logs between specific phone numbers of parties and witnesses. Okay, yeah, now we're getting somewhere. So if you want all text messages between Baldoni and Melissa Nathan, who was the PR crisis manager, wow, that makes sense. She's a PR person. And I want all text between Baldoni and Abel, who I think it was Jen Abel, who was also the PR person. Sure, that's somebody who's going to be relevant to whether or not there was a smear campaign.
What about all texts between Steve Sorowitz and Baldoni that have to do with Blake Lively? Is that something that you theoretically could get here?
I think so. But you put a limitation on there that makes some sense. I mean, yeah, it's not every communication between them. It's the ones that have to do with the Lively matter. And so there again, you've put a limitation on it. If they're sending texts talking about, their doctor's appointments or something else or financial information with Wayfair, that wouldn't be part of that. So it all comes down to what's reasonable. That's what it comes down to. So it looks like Baldoni's offering a reasonable solution. Let's see what Lively's response is, though, because on the same day yesterday, Lively and this is document 95, this is a letter from Lively's attorney to the judge, and they're kind of responding in terms of what they are willing to give. And of course, in this first paragraph, near the bottom of this first paragraph, she is saying that she's agreed to limit her request to contacts with specific third-party telephone numbers identified in advance. That's not exactly what Baldoni's letter said. So now Lively is saying that there is some limitations that we're willing to enter into. The burden, they also point out in the next paragraph down, that the burden of persuasion in a motion to quash a subpoena is borne by the movant. Okay, that's just legal speak. All that means is that they think that Baldoni is the one who has to come in here and prove that they shouldn't be produced. That's all that is. So let's go down to page 2. It's going to be the first full paragraph there. And we'll look at what Lively's saying. So about halfway down, it says, Miss Lively ceased communications among the Wayfair parties and specified under other individuals who have already appeared on communications tying them to the performance of publicity, crisis, or digital services for Baldoni versus Wayfair. Okay, if that was the limitation, that's not bad. That actually is fairly reasonable. And so because it's limited to people who have some connection to performing PR or publicity for Wayfair, that doesn't appear to be what the limitation was that Baldoni described in his letter. But in terms of what they're saying here, I don't know. It doesn't look too bad to me. What do you think?
No, I think as you see here, they started out with Lively's team started out with all documents without limitation, and that left these carriers, AT&T, T-Mobile, it left them in a position where they have to give all documents without limitation to what is even being asked, and it has to do with 2.5 years of data. And so you can see why Brian Friedman and Baldoni, they objected to this because it's just too broad, it's too much, and they're saying, hey, you got to limit this. And as you pointed out, it sounds like both sides are trying to win the game in front of the judge of we're limiting, but there still isn't full agreement on what that limitation includes.
So let's go down to the very last paragraph of the letter by Lively's counsel. And so, but they're still saying that the problem is they don't know all of the people who are involved in the publicity and PR crisis. And so they still are asking and trying to say that what we want is call and text logs.
Right.
And so they removed the request for location data. They further tailored the applicable time periods, which I don't know what they did. I didn't see what time periods they agreed to. And they only seek basic subscriber information, which is call and text logs, which Baldoni still has a problem with, which we talked about as to why he would. And so they're still saying, here's the problem. We don't know who all these people are. We know Melissa Nathan. We know Jen Abel. We don't know everybody that they used.
Right.
And there could be some secret person out there that we don't know about.
Right.
And that's why we need a more broad net.
Right. The problem I have with this is they haven't done the work. Lively's team hasn't done the work yet, and what they're looking for is a shortcut here. And it's a bit harassing in the sense that they know that no normal person is going to give 2.5 years of data to them to sift through to figure out who they wanted to pose in this case. So if I was the judge, I would tell them, well, it sounds like you have 2 of these people. Why don't you take their depositions? Why don't you ask them questions and ask them if there was anybody else that was included in this alleged smear campaign? Then if a new name comes up, if a text message that they bring to their deposition would lead you to ask additional questions about additional people, well, now you can go after that person's text messages. But they haven't done the work yet to get all of this information, from my opinion. There's a better way to do this, at least a less intrusive way to do this, and that is, you've got a lot to work with right now. start taking depositions, start asking people questions. And if more people arise to the surface, well, then you can ask those people questions as well. And if those people are lying to you, and I'll give you an example, Keith, if you have 8 people come to deposition and they all bring a different set of text messages and some of the text messages are left out, now you can say to the judge, we have tried, we have gone to the sources, but they're playing games. There's gamesmanship going on here. We're not getting all of the text messages. The only way for us to know, judge, for certain is to at least get a log. We don't need to see the text messages themselves, but we want a log. And maybe the judge would be persuaded at that time. But when you're just walking up saying, I want just to go on a fishing expedition, I want to stress Baldoni out by getting all of his private information, which includes, again, text messages with doctors and spouses and lawyers and priests and whoever else.
Right.
And those are things that should not be allowed in this case.
Yeah, that's right. It's simply too broad. So yeah, I think you're right. They haven't done the work. So what you would do is you would go and take depositions. One of the primary reasons for taking depositions is to learn information. That's why it's called discovery. So let's go now. Let's go to this is the good one. Filed just this morning, a letter from Baldoni's attorneys. And this is really where they come back with a strong punch. And if anybody thinks that these filings aren't done largely for PR purposes, well, this will change your mind right here. This is a huge PR statement that's done in a letter as to their argument. Now, this argument also has some legal significance, so it's not done gratuitously. I mean, there are some legal arguments here, but yeah, there's the money shot. Drop the mic, walk away. So we said it before. We've been saying it, I think, several times now. That SNL joke that Ryan Reynolds did will come back to haunt him. You're going to see the video on opening statement, closing statement, and oh, by the way, you're also going to hear about it probably in every motion that's filed from here until the end of this case. And that's what they've done. They said, look.
Well, wait, who's this letter from and who's it to and what's the purpose of it?
So this is from Baldoni's attorneys. It's in response to Lively's letter that was filed yesterday. So Lively says, we still want all call and text logs. Here's Baldoni's response. And Baldoni's response, and it also has to do, let me back up.
Yeah, isn't there doesn't Blake Lively want to have some privacy here and wants basically the court to shut down all the information in this case?
Yeah, so and that's an important piece that I left out. So they're arguing over the parameters of the protective order. So it's not just that the call and text logs are going to be produced, but they're going to be produced under a protective order. And we talked about the protective order a little bit last Friday. That's a document that's used a lot of times in lawsuits where people can send documents back and forth between the parties, but there's an order issued by the court that you are not allowed to share that information outside of certain specified people. And there's consequences if you do share it outside those people. And
there's a model order from the court.
Right.
And Lively's team did a bunch of red lines and additions to that model order.
And made it more restrictive. So what Lively's team wanted is they didn't just want the model protective order. They wanted another level of protection called attorney's eyes only that would further limit the people who could see information. Baldoni comes back and says, we don't need that. We don't need attorney's eyes only. The model confidentiality works just fine. There's no reason to worry about it. It's protection enough in this case.
And Blake's team is saying, and Blake is saying, hey, there's just too much focus on this case. There's too many public statements being made here. And what is the response here?
Yeah. And so Lively's team is saying, we need more privacy protection. And Baldoni's side is coming out and say, oh, really? Because you're the one who's been blabbing about half of this stuff anyway. That's their argument. And so here it is they're saying, worst of all, in a planned skit on SNL, Ryan Reynolds stood up and made a joke about her claims. So she's talking about her claims. She's joking about her claims. And now she's coming into court and asking the judge to protect this information. What's the point? And if we go back to page 1 of this same letter, and we can look at kind of what their point is here. And it's kind of interesting because, again, what they're really arguing at the end of the day is they're arguing that Lively's already disclosed a lot of this information. And so why do we now have to agree to her version of the protective order that makes this privacy issue so much more restrictive when it's simply not necessary? So let me just read this from page 1 of the letter that was filed this morning. So this is Baldoni's attorneys, and this is their argument. And they're saying, given...
Shit. Sorry, Keith.
Oh, no, no problem. Technical problems, especially when we're working with documents. So that's always the issue.
How do I let you in?
I'm already in on my side. Yeah, go back and leave the studio, and you can go back in at the very bottom. There you go. Go to the bottom. There you go. All right. We'll get it back on track. This is a good learning opportunity for us to learn how to work with documents. And he's back.
Well, that was fun. I don't know what happened there. Let me see if I can get us back. Go ahead, Keith.
It was so peaceful for like 30 seconds. So let me go back and talk about this. Is the letter from Baldoni in their response to Blake Lively's arguments. And Baldoni's attorneys say, given how actively the Lively parties have publicized and litigated Miss Lively's claims in the media, we are surprised to now learn how vehemently she wants to prevent the public from accessing material and relevant evidence. Okay, because she wants to protect it under the protective order, I think is what they're saying. And they go on to say, I'm in the second paragraph down there. They go on to say that the Lively parties provided the New York Times with Miss Lively's otherwise confidential administrative complaint. That's the CRD complaint filed with the CRD, and quote unquote, thousands of pages of original documents, including text messages and emails. But that's a direct quote from Megan Towie, who was the New York Times reporter who reported that. So in essence, what they're arguing is that, look, Miss Lively's the one who's talking about this. She took her CRD complaint, which is supposed to be confidential. She shared it with the New York Times. She shared texts and emails with the New York Times. She shared all of this information. But now she's coming into court and saying, no, we don't just need the normal protective order. We need something more than that. We need to have an extra protected order. And Baldoni's lawyers are just saying it's not necessary and it's going too far. And it's a little ironic that somebody who seems to have no problem talking about confidential information now wants to protect it. That's their argument. And I got to tell you, it's a persuasive argument. I mean, for somebody to want more protections when they've already said all of these things publicly, it's a persuasive argument on Baldoni's side. And then, of course, the kicker to all that was the part where they say, look, Ryan Reynolds went on national television, Saturday Night Live, and joked about this and talked about it openly on television. We knew for quite some time that Ryan Reynolds' statement on SNL was going to come back and bite him in the rear. And here's the first instance of that happening. And I'm sure it won't be the last. I mean, there probably will be multiple times when we're going to see Ryan Reynolds and his joke used against him in this way, because it's a powerful piece of evidence. It just is. So how many times do you think we're going to see Ryan Reynolds' words used against him?
I mean, it's going to be over and over, and you're seeing it now, even at this stage in the case, and then wait for his deposition, wait for other depositions. Again, if this is an SH claim, it's not being prosecuted properly on the other side. And I don't know who's making those decisions.
Yeah, it's a lot of missteps, and it's unfortunate because it certainly doesn't, well, I don't know if it's unfortunate. It's unfortunate if you're on Lively's side, if I was one of Lively's attorneys, because it makes your job a heck of a lot harder. And to have to see stuff like this in motions with the court, that's when you're just like, why are you making this harder on yourselves than you have to? You just don't have to be doing it. Let's look at the protective order that Baldoni suggested. And so if we scroll down to page 3, here's what happens. And so when documents are produced, either side has the right to mark those documents confidential, and they usually get stamped on the document. And once a document is identified as confidential, here's the parties who have access to it. So it would be the parties to the action. Okay, that makes sense. It'd be their counsel. It'd be outside vendors. And we talked about that a little bit before. So that's under C, outside vendors. It'd be D, any mediator or arbitrator. Okay, that makes sense. If you're going to resolve the case, you have to show them the documents. F, any witness who will be called to testify at trial or deposition, any expert witness, any stenographers, and then, of course, the court itself.
Let me ask you this. So the whole idea behind this protective order, and this is the model protective order, is to keep stuff in a case private, right?
Right.
So that people, it's not just these happen in all kinds of cases, not just cases that are where there's famous people involved. But is there, I don't want to pick on any vendor here, any copy service, but what's the problem with allowing a copy service or a vendor to do this? And then does the judge hold the lawyers accountable for the copy service and vendors they choose?
In theory, yes, because everybody's supposed to sign an NDA. But I guess my
What's
question,
an NDA?
everybody has to sign a non-disclosure agreement. And
so if I needed a bunch of copies done, sorry for interrupting, Keith, if I needed a bunch of copies done of some very sensitive documents that have been marked as confidential or attorney's eyes only or whatever it is, and I take this to a private, or take this to a vendor, a company, it's like Kinko's, but it's not Kinko's. It's a company that does this for attorneys. It's an attorney service. And I ask them to, make thousands and thousands of copies of this for a deposition that I'm going to, and I want to use them as exhibits and so forth. What's the downside of this, from a protective order standpoint?
There's just too many holes. I mean, if it goes to a copy service, let's say the copy service does sign the non-disclosure agreement. Okay, we're covered there. But how many employees are at the copy service? Or how many people are at the copy service who aren't employees, but they're, delivering something, or they're bringing extra paper or whatever. They're not associated, but they're around. And then you have information that could be potentially very valuable on the open market. I mean, how much would TMZ or somebody like that pay for, let's just say, for example, that there's just some horrible text messages between Baldoni and Heath where they're just saying vile things about Lively. Don't you think that some media outlet out there would pay big money for that information?
Yes.
And, the temptation's just too great.
Right.
And how do you even prove how it got out? So there's a lot of people on this list, and there's a lot of potentials for holes.
What about just leaks from a law firm? Intentional or unintentional?
It can happen. I mean, it can happen to anybody. No law firm is completely protected. And especially in this day and age with all the cyber, issues and hacking and, who knows what. So, I mean, things can get crazy. And to think that in this particular case, and the problem with this case is the information is valuable. Now, in just a regular case, where it doesn't involve celebrities and you have a protective order, it's not going to leak because nobody wants to leak it because it's not worth anything, and who cares. But in this case, information is it's going to be top dollar.
Yeah.
And so good luck keeping it confidential. I mean, maybe you can if you're really careful and vigilant, but it won't be easy.
So Keith, I'm going to be very unfair, and I'm going to ask you to make a prediction here. You have looked at these subpoenas, you know the issue, whether this information is going to have to be provided to Blake Lively's attorneys. Obviously, Brian Friedman and his team have objected and are really trying to narrow the scope here. What do you think happens with this request?
Neither side's going to get entirely what they want. I don't think the Lively side gets all calls and text logs going back for 2.5 years. I think that's too broad. I don't think the complete limitation where Baldoni only wants calls and texts between certain people is going to work either. I wouldn't be surprised if they have something that says that it's limited to the subject matter. So if you're talking about Lively or the movie production or anything like that, I don't know how AT&T or whatever these carriers are, I don't know how they sort that out, though. It's one thing if you ask Baldoni for all text messages between him and any party discussing Blake Lively, he can figure that out. He can go through the text messages. He can give those. AT&T is not going to do that. They're not going to look through every text message and say, oh, this is one about Blake Lively and this isn't. So it's really a tough problem. I think that ultimately, probably the best solution is, why don't you ask for documents, calls and text logs between Baldoni and known numbers? Let's start there. Let's see what that provides. And then why don't you go ahead, as you suggested, go out, take your depositions, do your discovery, see what you find. And then if you find something that leads you to yet another person, another number, then let's come back and let's allow that one as well. So let's do it in steps to make sure that everything's reasonable and we're not going too far. So that, I think, would be a reasonable solution. I wouldn't be surprised if the court does something along those lines.
And then, and turning our attention to the protective order. I mean, obviously, Brian Friedman, his team pointed out that Blake Lively and her husband were happy to put this on. I don't even know how many people watched the SNL 50th anniversary. It had to be a ton of people watching that. And they clearly didn't care that that was something that was put out in the public. And of course, they're using it to great effect here. They, being Friedman's team, is using it to great effect here. But what are your thoughts on the protective order? Is it the model order that the court will adopt? Is it Lively's more narrowly drawn up, or I guess more onerous protective order that they've redlined the court's model order to add additional requirements? What do you think is going to happen there?
I think the model order works, with the exception of if there were something like medical records. So if people, for whatever reason, and sometimes in these cases you do get into medical records or records with therapists or something, I think that would deserve a little bit more protection. And as a judge, I'd be more open to keeping that under the attorney's eyes only category versus confidential, which is more broad. But I think just for the run-of-the-mill information in this case, I think the model order works, and that's probably the way the court will go, but we'll have to see how the judge feels about that. And this is going back to your point when we started this discussion. That's why it's helpful to know the judge, helpful to know what prior rulings they made, helpful to understand, kind of get in their head a little bit. Is this the type of person who's a little bit more cautious and they're going to do the more restrictive? Or is this somebody who's a little bit more, you got to prove it to me until I give it to you, so let's just stick with confidential for now. So we'll see what kind of judge this is.
Just to give some context to the protective order, when we've had protective orders in the past, in similar cases like this, where the certain documents are marked confidential or for attorney's eyes only, we've actually had to have a paralegal as a full-time job to make sure all the non-disclosure agreements are signed by anybody reviewing these documents. We've had to call up our document producers and say, hey, this is an important case. You cannot disclose this stuff. If we want to use the stuff in deposition as exhibits, we have to get the court reporters to understand that this is confidential. We may not be able to send those exhibits around to be attached. Maybe we just all agree that we have those exhibits. And then, of course, if you want to use them at trial, you've got to give notice to the other side, because now, at trial, they would become public. It is a big job to keep this stuff confidential. And then ultimately, at the end of a case, Keith, we're going through all of our files and we're trying to shred everything. And then do we shred it ourselves? Do we call a shredding company? Do we walk out to the shredding company truck and make sure we see the stuff get shredded? Right. This really does add some layers of complexity to a case.
It probably adds millions of dollars of expense. Because each side's going to have a team that just administers this. And they're going to be lawyers and paralegals that their full-time job is going to be administering this. And you're talking about millions of dollars of extra expense to the discovery process just to try and make this work.
Yeah. So anyway, what's the takeaway from today after everything that you've reviewed?
Well, don't go on SNL and tell jokes about an active case. That's the number one takeaway.
All right.
And number two, the saga continues. So it's very interesting. It is good to see that the lawyers are making some progress and meeting and conferring on these issues. They have narrowed them, but we're not there yet. So it's going to be interesting to see what the final solution is here by the court.
And as soon as we find out from the judge anything, we'll jump on and give another update.
Yep, we'll keep you informed.
And we want to thank everybody for joining us. The comments have just been fun to read. The ones against us, the ones for us, we really have enjoyed that. And people, are really resonated with this case. And I've said, we had a guest on yesterday, and I talked about how this David and Goliath motif is there, and also the bullying issue. We've all been bullied in life by people that are powerful. And I think this has resonated with many people, where powerful people have hurt and harmed them in the past and not taken responsibility for the bad actions. And so this is a public spectacle that everyone can see. I would want to say, though, we work with clients, Keith, everybody hurts. Everybody has emotions. Nobody likes to be talked about poorly. And so if you're Blake Lively, if you're Ryan Reynolds, life is tough right now. It's got to be very painful, because you've taken years and years to build a reputation. And what it appears to us when we're looking at this is that they're losing the public relations battle right now. And so, but keep in mind that these are people. Yes, they're famous. Yes, they're powerful. Yes, they have wealth. But everybody has emotional responses to this stuff. You and I both believe this case should settle and resolve. And we'd like to see that happen. They've got to get there. And I think the way to do that is to start a dialogue. And maybe they already have started a dialogue that we're not aware of. Both camps need to start a dialogue on how do we resolve this case, because there is a resolution that can take place.
Yeah, and it's only going to go from bad to worse. I mean, again, sitting for depositions for Lively, I mean, it's just not going to go well. And Baldoni will take a few hits in depositions too. Look, everybody does.
Yeah.
Nobody sits and does, 100% perfect on a deposition. It's just too hard. But I think Lively in particular, and I think the problem too for Lively from the outset of this case, or once we understood the evidence from Baldoni, is her claims were just appear to be overstated and so easily shown otherwise just by the video and the text and everything we've seen. And I think that's another thing that really creates a lot of outcry by people and saying it's just so clearly wrong,
right,
based on what we're seeing so far. But again, the case is in the early stages. We got a long way to go. There's a lot of discovery. Evidence can come in that's good or bad. So we'll have to wait and kind of see how this plays out. But so far, Baldoni's definitely has the better hand here.
Well, we'll keep covering it and look forward to your responses to this video and future videos that we're doing.